Hi, I'm Janice Switlo, and today I'm going to talk about the recently royal assented Bill 1 that has been passed into effect in Alberta, the Critical Infrastructure Defence Act. And I have to be very clear up front that absolutely nothing in what I am about to say and discuss pertaining to this act is to be construed or seen in any manner as counseling to engage in any of the activity that this act purports to go towards. Why is it important to say that? Anybody who is discussing this act whatsoever must be clear about that. Why? Because the bill can be applied, fines can be applied in the event that you are seen to be counseling people or companies to engage in the subject activities to which this act is directed. Now, this royal assent was given on June 17, and it allows the government to levy heavy fines and possibly imprison anyone unlawfully interfering with infrastructure, including pipelines, highways, utilities, and oil and gas production facilities. Also applies to telecommunication lines, dams, and mines. Individual offenders face a fine of $1,000 for first infraction and up to between $10,000 and $25,000 for future violations. Corporations face a minimum of $10,000, rising to a maximum of $200,000, and it's cumulative, it's compounded, it's on a daily basis. So for each day, those fines is not a one-time fine. It's for each day that the alleged offenses are occurring. Now, before this came into effect, Arthur Noske, who's the Grand Chief of Treaty 8 First Nations of Alberta, said that the Critical Infrastructure Defence Act violates Indigenous and treaty rights, calling it a racialized bill and one that will aggravate tensions between police and Indigenous people. He said, "We knew this bill was enacted because of Wet'suwet'en protests," referring to, and everyone's fairly familiar with that. The protests drew thousands of supporters, and there was blocking highways, railways, etc. He says the intent of this bill is racially targeted towards First Nation treaty partners in this country. With all of the racial tension happening today, the government should realize this bill is not going to work, and the discussion on this, as I said, is to label it as racist. But if you read the act itself, you really can't find any racial undertones. It applies to everyone, if you will. I appreciate what he's saying, but it really kind of misses the real point in the trouble that Alberta is going to have with this act that it's passed. And that's what I'm going to explain today. Remember, I am not counseling any direct action. And in fact, if you review the decades of my assistance to Indigenous nationals and nations, it has not been organizing and directing direct action. I've been used as a peacekeeper when situations have erupted and used to find a way to resolve and restore the peace. So again, I'm going to hype on that because who knows what this government intends to do. There is basically no free speech when you have to be very careful in critiquing an act whereby it tries to encompass so much. So let's get to the main problem. Alberta, there's 3 treaties whereby permissions have been granted to the Crown. Treaties 6, 7, and 8. It's important to look at those treaties and understand that things like development of mines, putting down things like pipelines, it's Her Majesty that's given the permissions and her governments, not third parties. And I've spoken in earlier episodes explaining that companies are not subjects of the Crown because companies cannot be loyal. They're artificial entities. They don't vote in elections. They cannot swear allegiance and certainly do not in their formation do that. They are not subjects as that term is understood in international law. There are no permissions granted to third parties through the treaties. So you have this reality that Alberta is trying to apply. So let's just use the example of a mine, for instance. Alberta is trying to apply this to say, and let's deal specifically then how it applies, it may be applied to Indigenous nationals, to say that you can't go anywhere near there, okay? But here's the problem. Alberta laws can only apply where Alberta has jurisdiction. The jurisdiction that the province has depends on the jurisdiction that the Crown has. In other words, it's limited to and specific to the permissions granted to the Crown through treaties. Those treaties are still there. There has not been capitulation, though there's great effort to get all these treaty number tables confined to within a self-government process that brings them under Canada, destroys the concept of nationhood, and thereby would cause the treaties to fall. In which case, if all of that were to happen, then there isn't an issue here because Alberta would have total control. But that's not the legal reality on the ground today. And so if this is applied in an area where, say, a third party has constructed whatever is considered essential, basically everything, you know, that the definition is so vague and broad, it basically could encompass everything that's been improved on a property other than individual houses, for instance. So if they're trying to apply this, but yet that infrastructure had no right to be completed in the first place, because it was done, for example, by third parties and not by a Crown corporation or not by the government of Alberta itself, then you have an unlawful taking and using of land that is not permitted by the owners of the land, being the Indigenous nations of whose land that is. And then if they were to stand near there and say so and say this, Alberta's going to try to apply this act to them and say you can't do that. But it's trite to say that you cannot make laws and have them apply to land that you have no jurisdiction over, or land that has been improperly and unlawfully used and taken. And on that subject, we have on reserve, for instance, there's been a lot of things like roads and utility corridors, things like that, railroads, where land was taken and without permissions of the people, of the band members, for instance, on the reserve, but just taken by government for these purposes. Well, they got another problem with that, because the reserves are areas where the permissions have not been granted. They're reservations out of treaty, which is a common approach in any international treaties, and these are international treaties, where a party says, okay, fine, but this part's not included. So the whole point of reservations, truncated to reserves, is to say this is an area that's ours where we retain our full jurisdiction and we're not granting any permissions to the Crown. That means they could not just take portions of the reserve. The band members, for instance, could agree to give up their reserve for those purposes, but the fact is most of the early infrastructure just went ahead and did it. And there's no lawful basis for that. What that means is you have a whole bunch of roads, infrastructure, etc., that is not lawful. You cannot go ahead and do something that's illegal and expect the end to result to make it legal. That's not how it works. So Alberta, maybe it's time to clean all this mess up. Maybe these are great opportunities then. That, again, I'm not soliciting or counseling take direct action. I'm explaining that this bill is opening up a can of worms for Alberta, because anyone who's charged on that, the first thing to look at is, was this critical infrastructure lawfully put in place? And the key to that is looking at the treaties and who did it. And if there's been any expropriations on reserve, none of those are valid. Why? Because under the treaty, no permissions are granted. You could only get that if you had a proper, fully informed, freely provided consent to give up those reserve lands for those purposes. But you know, in so many situations, You've had these railroads put in, preventing access to fishing grounds, preventing access to core needs that would be satisfied in their absence. It's pretty hard to expect that the people would have consented to that had they been asked, which is usually why it was just done. Well, it doesn't work. You may have been able to bully people who had no access to lawyers, no access to do anything given the oppression they were continually living under. But today, especially when Alberta wants to take this step, Alberta's going to have to deal with defenses that come up like this. It's a warning. Be careful where you apply this act, because you may find that you'll end up undermining much of the infrastructure. Why? Because it's not lawful. It's all part of Canada's outlaw nationhood. And that's all I have to say.